Good afternoon and welcome to our program today entitled Public Policy and Politics, Compliance Tips for Your Nonprofit's Advocacy and Electoral Efforts. My name is Jeff Tenenbaum. I'm the chair of the Nonprofit Organizations practice here at the Venable Law Firm. And as you know, this is part of the monthly series that we do, a monthly series of seminars and webinars that we do here in our D.C. office on nonprofit legal issues. We have a nice crowd gathered here for lunch in our D.C. office and a very large crowd of a couple hundred people around the country gathered on the telephone for our webinar here today. This is a very interesting topic, an area in which I've done a lot of work over my legal career, and an area in which our speakers have done even more work over their legal careers. What we've decided to do today is really try to bite off quite a bit in today's presentation. We're going to cover a wide range of issues. For all of you, which is many if not most of you who do a lot of work in this area, you know that this is a complicated area of law, in part because there are so many different legal areas of law that come into play. And it's very difficult to analyze even a single issue or problem or question without bringing in multiple areas of law, from the Lobbying Disclosure Act to the Federal Election Commission Act, to the Federal Tax Code, to state lobbying disclosure and registration reporting laws, to federal gift and ethics rules, state gift and ethics rules. There's no shortage of complex legal issues that all intersect. We're going to try to touch on many of those here today. Obviously, we're only going to be able to scratch the surface as a result of a number of them. I think we have a record today in terms of our handout book. For those of you who are on the phone, you'll get an electronic copy of this emailed to you tomorrow. This definitely sets a record, perhaps in terms of both the number of PowerPoint slides and the number of additional articles that we've provided. Obviously, there's a lot more here than we're going to be able to cover here today. Don't worry, we will finish on time. But I would commend to you the materials. There's really a great wealth of materials here for you today. And like I said, not just the PowerPoint slides themselves, but there is some terrific ancillary articles in the back part of the handout that go into some pretty good depth on all of the topics, and then some that we'll be covering here today. For those of you who are familiar with the process, you'll all get an email tomorrow that contains not only the handout materials and PowerPoint slides and bios of the speakers, but also a recording of today's program that'll be posted on our website starting tomorrow. Feel free to share that with colleagues or others who you think will benefit from that. A couple matters regarding logistics. Questions for those of you in the room, feel free to ask questions throughout the program if you'd like, or save them to kind of breaking points or to the end. It's really up to you. We'll be sure to repeat the questions for those of you who are on the phone. And for those of you who are on the phone, you need to pose your questions using the chat feature on the webinar software. I'll be manning the laptop at the front of the room, and we'll pose those questions to our speakers at the appropriate times. Preview of our next two scheduled upcoming programs on May 14th. Our program will be entitled As Nonprofits Expand Their Global Reach, a special focus on tax, trademarks, and the Foreign Corrupt Practices Act. As always, our programs run from 12 to 2 o'clock Eastern, with a complimentary lunch here in our D.C. office from 12 to 12:30, and then the program from 12:30 to 2. And on June 25th, our program will be entitled Employee Leaves of Absence and Other Employee Accommodations Under the Law, What Every Nonprofit Needs to Know. Both are going to be really interesting, very different, distinct programs, but as always, we try to really cover the waterfront of different legal topics that affect nonprofits. Now, to our speakers, we're very fortunate to have three terrific speakers with us here today. I've had the good fortune of working with two out of the three for quite a long time, and the third for about the last year or so. It's been a true pleasure and honor to work with all three of them. They know this area of law, along with others, really inside and out, and you're going to benefit and see what a wealth of experience and expertise they have here today. To my immediate right, and I don't have time, unfortunately, to go through to do their bios justice. You have copies in your handout materials. But to my immediate right is Larry Norton. Larry, like I said, joined us, about a year ago or so. He came in and is now co-chair of our political law practice, along with Ron Jacobs. Larry is a former general counsel of the Federal Election Commission, a former assistant director and the Bureau of Consumer Protection at the Federal Trade Commission, worked in the Maryland Attorney General's office and the Commodity Futures Trading Commission. He actually started out his career as a litigation associate here at Venable, and we're very, very pleased to have him rejoin the firm in his new capacity. And he's been just an absolutely terrific addition to both our political law practice and our nonprofit group generally. Ron Jacobs, to his immediate right, is someone with whom I've worked for almost my whole time here at Venable. Ron is by far one of the best political lawyers in town, but also a lawyer who really understands the full range of issues that affect nonprofit organizations. He really gets the full picture and really grown into a role that's far beyond the political law issues and really covers all aspects of nonprofit law. Like I said, Ron co-chairs our political law group, has also spearheaded a number of investigations of our nonprofit clients, congressional and otherwise, has done a terrific job in that role, has spearheaded a number of legal audits of nonprofit organization clients of ours, and is a key member of our team. And finally, to Ron's right is Janice Ryan. Janice started her legal career here with us at Venable as a first-year associate after having been a summer associate with the firm. She's become an absolute superstar in our nonprofit group, has been with us for several years now, has really developed a subspecialty in the political law area, and you'll be very fortunate to hear from her today. So with that, one last thing you'll see on the last slide here today, several links that you can feel free to reference when you're back in your offices, links to where we have recordings of all of our nonprofit legal programs, a link to where we have all of our publications. There's at least 600 or 700 on there on every conceivable nonprofit legal topic, searchable by topic area, and finally a listing of our upcoming events such as programs like this. So with that, I'm going to turn it over to Ron to get us started. Ron?
Great. Thanks a lot, Jeff. As Jeff said, we have a lot of different material to cover today, and part of that is because we know we've got a wide variety of organizations represented here in the room, from 501c3s, C4s, C6s, and probably some others. And so there'll be different topics that apply more heavily to some of you than others at different points in time throughout today. But our hope is that you'll be able to hear things that will benefit you, even if you're a C4, maybe what a C3 does. C3 maybe decides it wants to form a C4 tomorrow, things like that. And of course, there's always the possibility that you'll be working in a different capacity at different times. So hopefully you'll find all of these different topics of interest to you as we go throughout the day. And with that, I think we'll dive right in and get started with our first section on political action committees.
Thank you, Ron. I think if political action committees were a flavor of ice cream, they would probably be vanilla. And I don't say that to disparage any of the vanilla ice cream lovers in the audience, but only because they're not the organization that gets all the buzz. That's been, of course, super PACs, which we'll talk about momentarily, and 501c, particularly 501c4 organizations that have been active in our space. But political action committees, in fact, have been around since the mid-'70s, and notwithstanding the fact that they don't get a lot of buzz, they've grown enormously since then. And the statistics I was able to find in preparing for today was that in the 2012 election, PACs, that is corporate PACs, trade association PACs, gave federal candidates a total of $1.2 billion. Billion with a B. So that's not a species of organization that is disappearing anytime soon. Normally, super PACs are formed by corporations or people within a particular industry, and the slide talks about why a PAC, and in large part, what a PAC can do for an organization is to channel political activity away from areas of legal risk. So notwithstanding that the law has changed a lot, and the Supreme Court issued this ruling a couple of years ago in Citizens United that unleashed corporations to spend lots and lots of money, corporate entities and incorporated trade associations still cannot make direct contributions to federal candidates. But organizations like trade associations and other incorporated entities may continue to make contributions through a PAC. And so you have an entity that's been around for 30, 40 years, that is well established in the law, that can channel activity away from the entity that can't make contributions. The name of the PAC is always the name, shares the name of your C4 or C6, and so it's the only way as an organization you can make contributions that are identified with your organization. And it's a means to support office holders and candidates who understand your industry and share your concerns. So who funds a PAC? Well, again, it can't be the trade association general treasury because corporations can make contributions, but it's certain individuals may be solicited for PAC funds within your organization. And we're going to talk first about individual membership organizations. So in that case, for that kind of organization, you can raise money for your PAC from your executives and from individual members and from members of their immediate families. You can also solicit your board members if they receive a stipend or a fee for serving on the board or otherwise qualify for an individual member. So that's where the money comes in from to make PAC contributions.
And just to clarify, the individual member, we don't mean a single member. We mean individuals as opposed to corporations or other entities.
That's right. And which is a good point, and we're going to talk in a moment about corporate membership organizations. So again, who are your members? And this can be a little tricky because the Federal Election Commission's concept of a member is not necessarily your concept of a member, but it's important for purposes of soliciting. Essentially what the FEC says is that for someone to qualify as an individual member, they must satisfy your requirements for membership. They have to accept the organization's invitation to become a member, and they have to have a certain kind of relationship with the organization, either financial or participatory. And there's an example there. In the financial side, that's normally through dues payments, and on the participation side, there are any number of other ways that you could vote and participate in the conduct of the organization.
And the idea with why the FEC has these rules is so that you're not just sort of soliciting the world, deciding that everyone and anyone is going to be your member, that anyone who's signed up for an email list, for example, suddenly gets to be a member. There has to be these concrete attachments to the organization. And as we said, there, in addition to individual membership organizations, and there's also organizations that have corporate members, where the members are actually the companies, particularly in the trade association context. And the rules here are a little bit different for who can be solicited for the PAC. And the rule here is that you can solicit the restricted class of the member companies who give prior approval. Now, the restricted class of your member companies are the executives, meaning the salaried employees with decision-making authority, shareholders of the company, the families of those two groups, of those companies. And also, and importantly, as we'll talk in a second, it's often a subset of these individuals, so that when you're dealing with prior approval, it may not be that you're going to solicit the entire restricted class. Now, I said it can only be done if you have received the prior written approval from the member company. And the prior written approval has to be written, signed for each year. The FEC says that you actually have to have a line for each particular year where the corporate representative signs the form. And a company can only give approval to one association per year. So it's not as if a company can be a member of multiple associations and give prior approval to multiple associations. Now, the membership does flow to the particular corporate entity. A parent company can be a member of one association, a subsidiary of a different association, and they can give that prior approval to different associations. Now, one of the things that comes into play with prior approval is that everyone always thinks of it as sort of a very formalistic legal process that you have to go through. And what I've found that where associations are most successful is when they simplify and when they try and make prior approval sort of a little less daunting. And a couple things to do with that. One is to think about the prior approval almost like you would think of a solicitation. Now, again, you're not allowed to solicit people for money until they've given prior approval, but the idea is that you explain the benefits of the PAC. You explain why you have the PAC and why you hope that they'll participate in the PAC. It's not simply handing them a sterile piece of paper. It's really a package that lays out why the PAC is so important. And then the other thing that I found is very helpful is that some companies feel like if they're going to sign away their prior approval on the form, they get very nervous. They think that you're going to bombard their employees with email or with mail, and that you're really going to sort of get into the inner workings of the company and cause problems for them. So one of the ways that I've seen associations be very successful is to say, okay, we're not looking to solicit every one of your executives. We're not looking to suddenly mail out to every one of your shareholders. What we really would like from you are a list of your 5, your 10, your 15 executives who are involved in the association who would be interested in contributing to the PAC. And if you want to do the solicitation for them, that's great. We'll send you the materials and you can reach out to them, or the association can communicate with them directly. And that's really, in my experience, has been a way that helps with getting this prior approval. It gets around people's sort of roadblock of why they're concerned that they're signing away too many rights or they're going to cause problems for their organization. Even with prior approval, one of the things that I find, there are a couple of sort of issues that come up all the time for associations. One of them is what I call the invitation to the events conundrum. And that is, well, I want to include in my materials a PAC event. If we're having our annual meeting and I want to be able to list invite people to come to a PAC event, but I don't know who's had the prior approval. So how do I get to do that? How do I get around those problems? And so what I suggest doing is, you can't say, come to our PAC breakfast, the recommended contribution is $1,000, if you don't have their prior approval. So the way to do that is to set up in your materials a note that says you're having a PAC reception, suggested it's invitation only, and then if it's an electronic form or paper, you click here or call for more information. When the person calls to learn about the PAC event, it's not, okay, you can come if you give $1,000, but rather, okay, have you given us prior approval? If not, let me tell you about prior approval and hope you'll grant prior approval so that I can send you and your colleagues an invitation. And so that's a way to try and get around the roadblock of making sure that you've given prior approval before you're soliciting the individuals associated with the company. Another issue that comes up is people want to know, well, can I have a PAC booth at our association meeting or at our annual conference? And the answer is yes, you absolutely can, but the issue is, what are you doing at that PAC booth? And again, the way to handle this is, if you have, what I would suggest is that you have lists there with computer, or perhaps on the computer, so you know if someone from company X comes up and says, hey, what's the PAC? I'd like to learn more about it. You can say, oh wait, you know what, you're not, we need prior approval from your company. Let me explain prior approval. But if someone from company Y comes up, you can say, oh yeah, great, we have prior approval. Here's the contribution form. Please sign on the dotted line and give me your credit card. And then you've got the PAC contribution. So that's really sort of some important things to keep in mind, that you're focusing on not making a solicitation unless people have given prior approval. And now Janice will explain to us what a solicitation is and is not.
Thanks, Ron. So when we're talking about PAC fundraising, the key message that you want to take away from what Larry and Ron have just described is that you are only allowed to solicit contributions from a narrow group of people. This is your restricted class. You may not solicit the general public. This means you have to take some care when you're talking about the PAC or having communications with people who are not part of your restricted class. So what is a solicitation? It's obviously an explicit ask for money, but it's not just an explicit ask for money. The Federal Election Commission takes a pretty broad view that certain types of communications that encourage support of your PAC are likely going to be considered solicitations. So for example, if you have a communication that publicizes your PAC's right to accept unsolicited contributions, that's considered a solicitation. If you have a communication where you provide information about how someone can make a contribution to the PAC, that's also considered a solicitation. And just generally, any kind of communication that encourages support for your PAC. Perhaps you're lauding certain employees or executives for their support of your PAC in a newsletter that goes out to your association members, and perhaps the newsletter goes to a number of people who are not part of your restricted class. You may have a prohibited solicitation problem there. So what's not a solicitation? There are certain communications that you can make available to the general public that won't be considered solicitations. You can announce the existence of your PAC and explain the legal rules that apply to it. You can also provide factual information about your PAC receipts and disbursements. You can identify the number of your contributors or perhaps the number of candidates that you've supported. Keeping those limitations in mind, there are a variety of permissible methods of soliciting contributions from your restricted class. Your solicitations can come from the association that sponsors the PAC or from the PAC itself. They can be, oral, perhaps at a PAC event in person. They could be through the mail. They could be through the internet. Perhaps you have a restricted section of your website to which only members of the restricted class would have access. You could do solicitations in that way. You need to keep in mind that you can't use, for example, your corporate members to get around the prior approval requirement. If you don't have prior approval to solicit an individual from your corporate member's restricted class, you really cannot solicit them. And then company payroll deduction systems are a very convenient and effective way of collecting contributions from your restricted class. For a trade association, the association can use its own payroll deduction system to collect contributions from its executive personnel. And your corporate members can also use their payroll deduction system to collect contributions for your trade association's PAC as well.
Well, thank you, Janice. I've always thought that one of the real great selling points of a PAC, trade association or corporate PAC, is that you can tell contributors or prospective contributors that we're going to use every dollar of your money to make contributions. There's no overhead required in running a PAC. And the reason is that the so-called connected organization, whether that's the trade association or the C4, can handle all the administrative expenses in running the PAC, which are not significant, but to the extent that they exist, they can be paid for out of the organization. So if there are bank fees that are connected to running the PAC, if you want to order stationery, if you hire a good lawyer to advise you periodically when you have questions, all of that can come out of the organization's treasury and not out of the PAC funds. You can also pay for things like transportation costs. If you have someone who is going to take a cab or even a plane in a hotel room to go to a fundraiser and deliver a PAC check at that event, that transportation can be paid for out of the organization. So really dollar for dollar, you ought to be able to use the funds you raise to make contributions to candidates. One of the sort of underutilized features of the law is that PACs can do things to incentivize donors to contribute. And again, those incentives can be funded out of the trade association treasury or by the corporate members. So it's common that PACs will have raffles or giveaways in connection with everyone gets a certain swag if they make a contribution, or we're going to have a prize at this event, and that's going to go to the contributor. That's going to go to everyone who's contributed is going to be in the drawing, that sort of thing. And the only really limitation under the Federal Election Commission rules is that the prize can't be disproportionately valuable to the contributions. The FEC uses this thing called a 1/3 rule, which is that the value of any item that you give away can't be any more than 1/3 the amount of all the contributions you raise through the incentive. And that's really to prevent the organization from essentially recycling treasury funds back into the PAC. But apart from that 1/3 rule, there's an awful lot of latitude there. And again, one of the features of federal PACs that I think is often overlooked by organizations that have them or are thinking of forming them is that in many states, a federal PAC may make contributions to candidates in non-federal races, candidates for governor and state legislature, with either minimal or almost no reporting requirements. And this map gives you a kind of general lay of the land, but you can see that there are quite a few states marked green, which are states where it's quite easy to make a contribution from your federal PAC to a state candidate, often with nothing more to be done than filing a copy of the FEC registration for your PAC and the page of your report that discloses the non-federal contribution. And of course, there are still a number of states where your organization, your incorporated C4 or C6, can make direct contributions to state candidates not anyone running for federal office, directly out of the corporate treasury without bypassing that PAC entirely. Many of those states, those green states in this map, are states where corporate contributions are permitted but are limited in some fashion. There are usually affiliation rules in these states to be aware of. If you have multiple organizations that are commonly owned or controlled, there may be a single limit that applies to all those organizations. And in a couple of states, Louisiana and Missouri spring to mind, your C6 or C4 can make a contribution, but there's a requirement that the organization receive a formal board resolution authorizing the making of political contributions before a corporate contribution can be made. I'm going to turn it over to Ron to talk about tax issues.
There is one, with respect to making direct corporate campaign contributions, one thing to keep in mind, and it's something called the 527F tax. And that is probably one of the strangest taxes in the entire, however many 72 volumes of the tax code there are. It's a tax on the lesser of your net investment income or the total of your political expenditures. So if you're making direct corporate contributions and you have virtually no investment income, you'll pay a little bit on your investment income. If you have a large investment income but relatively small total amount of political expenditures, you pay the tax on that amount. So it's something to keep in mind. I've had some clients before who have made political contributions and then not realized that they had to deal with this 527F tax. So it's just important to remember that it's there and can come into play. That's our survey of PACs for C4s and C6s for today. Now we want to switch gears a little bit and talk about communicating with the public. And sort of the general rubric that we want to talk about, or you'll think of in terms of sort of independent expenditures, the things that Citizens United sort of allowed you all to do directly. But there's a range of things you can do that we want to go through and explain, because there's different regulatory requirements on different pieces, and they come into different, there are different restrictions on, for example, a C3, what it can do in terms of lobbying communications to the public versus what others can do on actual express advocacy in talking about candidates. So the way I kind of draw this distinction is to put issue advocacy on one side and campaign intervention influencing an election on the other side. And one of the ways to think about that is to kind of think about the different calls to action in your communications to the public. Is it to say to learn more about this issue? Call your member of Congress and tell them to vote yes on immigration reform or vote no on immigration reform. Let's send this guy to Washington, D.C., or vote for this person. So it's a range of things that are in there, and as I said, there are various laws that come into play with different ones. Now, when we're talking about communicating with the public, it's unlimited. A lot of people heard about the super PACs and the independent expenditures and immediately think of the 30-second television ads that we were bombarded with in this TV market during the election time, where there was one right after another. But one of the things that associations and nonprofits can do besides television is do smaller kinds of media, whether it's web or social media, telephone calls, radio, email. There's a whole host of activities. Some folks have suggested that perhaps those kind of activities may even be more effective than the 30-second television spot. So as we go through these different communications and the things you can and can't do, we want you to keep in mind that there's a lot of creative ways where you don't have to spend six figures on a media buy in a television market to be able to make a difference here. One of the things, as I mentioned, that depending on the type of communication we're talking about, there are different regulations that come into play. If you're doing telephone calls, you have to think about something called the Telephone Consumer Protection Act or state telephone laws. Now, generally speaking, political communications are exempt from the TCPA, but there are restrictions on calls to wireless devices, certain restrictions on text messages you have to think about and remember how those come into play. There are some states that have rules about different polls. If you're doing a push poll in certain states, there are certain disclosures that have to be made. That if you're doing TV, broadcast or radio on TV, there's sponsor ID rules. So even if it's not something where you're not saying vote for a candidate and you don't have to have the particular language required by the Federal Election Campaign Act, the FCC still has rules that say paid for by at the bottom of a commercial in a certain type size so that people know who's sponsoring that. And then the other area that's often overlooked are state grassroots lobbying laws. And a number of states have these where if you are engaged in grassroots lobbying, either in conjunction with actual sort of shoe leather lobbying or on its own without having any other registered lobbyists. States require registration. Maryland, for example, has a grassroots lobbying statute. Pennsylvania has a grassroots lobbying statute. New York has a grassroots lobbying statute. And so keep in mind that some of these states have fairly robust donor disclosure rules along with these grassroots lobbying laws. So you have to think about whether your communications are going to fit within those grassroots lobbying laws, what needs to be disclosed before you sort of jump in full bore doing something that most people say, oh, it's grassroots lobbying, I don't have to worry about it, it's not campaign intervention, so I don't have to worry about the FEC. Well, there are other rules that can come into play that you want to watch out for.
There are a number of state laws now that require you to comply with the grassroots lobbying laws if all you do is have a website that facilitates visitors to the site to determine who in their state is taking one side or another on an issue and how you go about contacting them. So you may not have done anything affirmative like an email or a letter, but because you've got this website where you're helping people figure out who to contact in connection with an issue, you're subject to all these laws Ron's talking about.
As I mentioned, there's obviously a range of communications. And now what I wanted to do was kind of lay out 4 broad categories because each of these are particular legal terms that bring into different regulatory schemes to bear. So starting on the left side, there's grassroots lobbying. And again, the idea behind grassroots is that there's a particular call to action. Call your member of Congress, call your state legislator. It can be done through any medium at any time. For a 501c3, there are limits on how much grassroots lobbying you can do. For C4s and C6s, you have an unlimited amount that you can do. And then as we mentioned, there's some possible state disclosure involved. Then the next category is probably, yes?
With the grassroots, is there any, with the states that require the registration, is there any de minimis threshold below which you don't have to?
So the question was with the state grassroots disclosure, whether there's a de minimis threshold, an amount of spending below which you don't have to register. The state laws, they all vary. I think in general there's going to be a certain amount that you can spend without, although as Larry pointed out, a number of states have taken a pretty aggressive view on things like just creating the website that requires disclosure. So it's just a function of knowing which state you're involved in and checking out what the law says in terms of whether there is a threshold or not. I think usually with state laws, you want to at least apply a bit of a rule of reason to make sure you're actually crossing the threshold that you're going to be involved in that state. Because one of the things that I think is dangerous is going out, registering very quickly, only to realize maybe your activity is not as robust as you expected it to be, and then you miss the next lobbying disclosure report or the next grassroots disclosure report you're supposed to file. You wind up with a black eye from the state ethics commission there. So you want to make sure it's that you really need to register, and you want to be cautious about that. That's a very good question.
And one other good reason for not necessarily rushing into registration. Of course, in a lot of this stuff, we're not talking about whether or not you can engage in this kind of advocacy activity. It's not a limitation. It's just a regulation of it in terms of reporting, registration, disclosures, and the like. But as we'll talk about a little bit later, sometimes other restrictions do kick in once you do register. Some gift and ethics rules, for instance, only kick in for registered lobbyists. So you always need to be cognizant of kind of what new realm of regulation, including actual restrictions on activities, might come into play once you register.
Very, very good point. The next category that we lump things into are issue advocacy, and this is probably sort of the least regulated category out there. It focuses on issues, but unlike grassroots lobbying, it doesn't include a call to action. It's just learn more about this piece of legislation or understand what Congress is thinking about right now. Again, this can be done through any medium at any time, but you have to remember if you mention candidates in there, it can start to push it into these other 2 categories that we'll talk about in just a second. Any organization can do issue advocacy. 501c3s can do unlimited issue advocacy as long as they're careful not to make it grassroots lobbying. And again, some states, depending on the way the grassroots lobbying disclosure statute is written, may actually capture some of this issue advocacy kind of thing. The next bucket is something called an electioneering communication. And this was a term that was first implemented under federal law as part of the McCain-Feingold Bipartisan Campaign Reform Act back in 2002. A number of states have picked up with this concept. And the idea was that Congress wanted the FEC to be able to regulate what they deemed to be sort of sham issue ads, ads that were ostensibly about issues that were really attacking or supporting a candidate. So the hallmark of an electioneering communication is that it refers to a clearly identified candidate for federal office or for state office if it's one of the state laws. In the federal level, it's only if it's broadcast on radio or television, so it's a fairly limited scope. A number of states, though, have taken the concept and run with it so that it applies to other kinds of communications as well. And then again, with the idea is that there's a certain time limit to these. In the federal level, it's 30 days of a primary election or 60 days of a general election. Again, any organization can make these. And what's interesting here is that even a 501c3 that's doing issue advocacy that may include a reference to a candidate may be required to register and report with the FEC for making an electioneering communication. So this is one of those areas where the tax code says one thing and the campaign finance law says quite another thing. You have to make sure you're sort of dotting the I's and crossing the T's for both areas of those. And then the final category are the independent expenditures, which again, the idea here is that you're sort of a more explicit statement that you're going to vote, ask a person to vote for or against a candidate. And here, there is a restriction on 501c3s. You cannot engage in express advocacy or it would be considered intervening in an election. And C4s and C6s face limits on the amount of, that they can spend on independent expenditures. So to talk about what independent expenditures are, I will hand it back over to Larry. There we go.
One of the things that's probably apparent by now, if it wasn't before you walked in the room, is that the regulation of communications is all over the map, really, literally and figuratively. There are in lots of ways, regulation is governed by the kind of communication. Is it an independent expenditure? Is it an electioneering communication? And then in many respects, the regulation is media specific, sort of siloed to whether you're using radio or television or something else. The internet and social media have been interesting because the Federal Election Commission, for instance, has taken the view that because there's really no cost in sending an email or putting an ad up on your website, your own website, that shouldn't be regulated. On the other hand, states have not adopted the view and are regulating that kind of activity the same as they would anything else. And so there are these filters that you need to run, your sort of traps you need to think about as you're planning a communication strategy. And I want to talk for just a couple minutes about one type of communication, and that's the independent expenditure, the communication that expressly advocates for or against a clearly identified candidate. And that sort of sounds relatively simple in concept. Well, okay, you say vote for Joe, that's express advocacy. I've got to look at usually the campaign finance rules, Federal Election Commission or state. The rub is that while those things like vote for or elect Smith and Jones are clearly express advocacy, there's a whole other category of communication that under federal law and the law of most states is considered the functional equivalent of express advocacy. Nobody could take from that message anything other than that you want to see that candidate elected, either because of the time it runs, because the fact that there's really no issue there or no request that anyone take any action on an issue. For whatever reason, the regulator says that's express advocacy. So if you pay for a communication that contains express advocacy, a call to vote for or elect or an appeal that attacks somebody's character but doesn't really say anything at all about taking action on legislation or a proposed issue, that's going to be regulated for the most part as an independent expenditure. And again, that could take the form of billboards, email, mail, regular mail, anything like that. An independent expenditure under the federal and other laws is regulated regardless of how close it is to the election. So you could do it now about an election that's almost 2 years away. I don't know why you would, but it doesn't matter, unlike the electioneering communication rules, whether the election is a month or 60 days away or something like that. And a key element of an independent expenditure, as you might guess, is that it has to be independent, that is not coordinated with a campaign or with a party. Why is that so important? And we hear all the time about They're coordinating, that ad was coordinated with this candidate or campaign. And the reason for that is that under the law, if you talk to someone in the campaign and they say, it'd be really great if you could run an ad on this issue. It'd be really great if you could fill in these 3 weeks when I'm going to be out of money. Under the law, that's treated the same way as if you gave the money to the candidate and the candidate paid for the ad. In other words, it's treated like a contribution. And it's going to be subject to the limits that apply to contributions, and in some cases the prohibition if the funding came from a corporation or an unincorporated trade association or C4. So some separation has to exist, some independence has to exist between any organization that is funding these independent expenditures and the campaigns, the candidates that you're supporting or opposing. And the next slide shows, oh, of course.
So in this instance, you're talking about the influence of voters with regard to selecting a particular individual who's running for an office in a particular election. Would that also apply to, for example, calling a member of Congress over an issue that's before Congress? Would it apply to a general issue like we need to higher pay for teachers when there's no particular legislation on the table?
Well, excellent question. The question is whether the concept of coordination is relevant if all your organization is doing is running an issue ad that very clearly calls for action on an issue and doesn't say anything about electing or defeating the candidate. Might that be considered an in-kind contribution? Under the Federal Election Commission rules, it would not. The Federal Election Commission says that if your communication itself, the content of the communication, doesn't meet certain tests that tie it to an election, either express advocacy or proximity to the election, then it's not going to be coordinated. And you don't have to worry about making an in-kind contribution. Unfortunately, and this will be a refrain you'll hear throughout, the states don't necessarily line up the same way, and they don't all line up the same way as either the FEC or one another. And so you have to be careful under state law that if a candidate says, you know, this gas tax issue is really probably going to move the election here. If you could run ads on that, it would be great. I want to stay away from it, but if an outside organization would do that, that would be really helpful to us. That might be considered an in-kind contribution, a coordinated expenditure under state law. It would not likely qualify under federal law because there would not be a reference to the candidate or perhaps not proximity to the election. But in state law, you need to be careful. So this slide demonstrates some of the ways under the FEC rule you can coordinate with a candidate, the most obvious being you've been asked to run an ad. Others are a little more nuanced. You've been involved in some discussion with the candidate about the candidate's plans or needs. And the last one, which can get very tricky, is what if you sort of borrow an image of the candidate from the website or from a brochure and you use that in your ad because you don't have a photo available of the candidate, but the ad is really going to be about an issue and it's going to be a call to action on an issue. Under the federal rules and the laws of some states, the use of campaign material can be considered a coordinated expenditure, and there are rules about that that are too complicated to get into in much detail, but it's something to be aware of. One of the real tricky ways that you can coordinate under the federal rules and under the laws of many states is if you, as a member of the outside organization, and the candidate hire the same vendor. So you hire the same firm to write your ads or to do the media buys. And through the common vendor, information is exchanged about what the campaign needs so that you, as the third party, the outside organization, would know what to do. That's considered coordination. If someone had a high-level position with the campaign within, under the FEC rules, 120 days, and they came to work for your organization and assist you with media strategy, then your ads and expenditures would meet at least one test under the federal rules if the ad itself met the other. So that can be coordination. All of this is to say that if you are going to be involved in distributing either ads or email communications or anything else that advocates for or against candidates, that you need a coordination policy in place. It's never been more important than now. And when I say a coordination policy, I mean something in writing that goes to your senior people and anyone involved in media development and distribution, and that goes to all of your vendors, and that where everyone is told and agrees that they will not use information that they obtain from the campaign, that they will not, that if they're a vendor, that they are not simultaneously working for the candidates that you're supporting. They don't need to be terribly complicated, but as a way of protecting yourself against a potentially expensive and very invasive investigation, the coordination policy can be a lifesaver. I think your question earlier sort of touched on this slide, which is trouble areas for nonprofits, and that, as you can imagine, comes up necessarily because you're interacting with elected officials and members of Congress all the time about issues. You're lobbying, your PAC is making contributions. It's important in those kinds of engagements not to be talking about the campaign's plans or projects or needs, because if you later fund an ad or a mailer or some other communication that advocates for or against a candidate, those earlier conversations could turn your expenditure into an in-kind contribution, which is probably well in excess of whatever the applicable limits are. Who can make independent expenditures? Lots of different organizations can do this. In the wake of Citizens United that said that corporations can make independent expenditures so long as, again, there's no coordination with the candidate. And so trade associations, 501c4s, PACs, super PACs, everybody but 501c3s, which for tax reasons are unable to make them. So I think with that, I'm going to turn it over to Janice to talk about super PACs.
Thanks, Larry. In the next few slides, I'm going to discuss types of organizations that can engage in independent expenditure activity, highlight some of the regulatory considerations involved in choosing perhaps one vehicle over another. So let's start with super PACs. What is a super PAC? It's kind of a fun word that we have to describe an independent expenditure committee. This is a regulated political committee that's subject to federal or state campaign finance registration and reporting requirements. Super PAC makes independent expenditures only. Oops, I have two pieces here. It does not contribute to candidates, and it may not coordinate with candidates, as Larry has just described. It's registered depending on the types of elections in which you're going to participate at the federal level with the Federal Election Commission, or at the state or local level with the applicable state regulatory body. And the thing that makes super PACs special is this last element here. They can make or they can receive unlimited contributions to further their independent expenditure activities. This last element has developed out of a series of court cases, most directly the case called SpeechNow.org versus FEC, in which the logic is that if individuals and corporations are permitted to make unlimited expenditures out of their own finances for independent express advocacy, why not allow those individuals or corporations to get together in the form of a committee and engage in that kind of activity together? So the key here is that independent expenditure committees at the federal level, and for most state level regulators have the same position, though we'll talk about some exceptions in a bit, is that the committees are not subject to the same kind of contribution limits that are applicable to ordinary political committees. As Larry mentioned previously, 501c4 and 501c6 tax-exempt organizations may also make independent expenditures consistent with campaign finance law and also consistent with certain provisions of the tax law. These organizations are organizations that have as their primary purpose something other than influencing elections. So for 501c4, our social welfare organizations, they must be organized and operated primarily for the benefit of the social welfare. For our trade association or professional society, 501c6 organizations, they must be organized and operated primarily to benefit or promote a line of business or industry or a profession. If the organization has as its primary activities influencing elections, they have two potential problems. The first is with the IRS. The IRS might come to you and say you no longer qualify for your tax-exempt status under 501c4 or 501c6. And the other issue is that they might be subject to regulation as a political committee under the Federal Election Campaign Act or under applicable state law. Yes? The question is, can I comment a little bit more on what it means to be primarily engaged in something other than influencing elections? There's been a lot of controversy about tax-exempt organizations being involved in elections, particularly with the last election. As this slide says here, the general rule of thumb that folks in the regulated community understand to be the case is that something less than 50% of your activities must be something or can be influencing elections. We don't really know the answer about where the line is. Do you guys have any other comments on this?
I think it's an area that the IRS has not provided a lot of guidance on, and it's an area where we're seeing a lot of controversy because the IRS has sent questionnaires to a number of organizations to try and learn more about this. But it's not like a hard and fast rule where you can say, okay, you can spend up to this amount or you can do these things and you'll be safe. We say that it's less than 50%. I think organizations that want to be a little more cautious tend to do more in maybe the 30 to 40% in the upper range to be on the safe side. But no, there's not a hard and fast bright line rule.
It's also an area where Congress has been very engaged as of late, putting a lot of pressure on the IRS to kind of take a look at particularly 501c4 organizations that are heavily engaged in influencing elections. The IRS actually has a very large project underway. A lot of the key exempt organization staff are focused on this area, this special compliance project right now. It's unclear what will come out of that. Some guidance could come out of it that makes it clear to everyone where these limits are drawn. That may or may not happen. The other thing to keep in mind is when we say less than 50% or more than 50%, we're not necessarily talking about an easy benchmark to measure, as we see in other areas like lobbying, for limitations for C3s, unrelated business income, other areas where there's substantiality tests and things like that. It's not just necessarily based on expenditures. Sometimes the IRS makes these determinations based on other factors like staff time and volunteer effort and things like that. So that makes the analysis even more complicated. Although if we're talking about primarily, the purchase of ad time and things like that, then the analysis is probably more straightforward.
So how can an organization be active in the independent expenditure space? You really have two options. You could make independent expenditures directly, or you could make a contribution to a super PAC. Even if you're not a political committee, you are subject to campaign finance reporting requirements if you make independent expenditures. You'll be required to disclose your independent expenditures. Sometimes, usually there are rapid reporting requirements. So if your expenditures reach $10,000, you may be required to file a report within 48 hours of making the applicable communication. When you get closer in time to an election, that threshold goes down. So if your expenditures exceed $1,000 within 20 days of an election, you need to file a 24-hour report. And you will also be required to disclose your contributors who made a donation in excess of $200 to further your independent expenditures. The disclosure calculation is a bit different when an organization chooses to make a contribution to a super PAC instead of making an independent expenditure directly. Under federal law, when a 501c4 or a 501c6 makes a contribution to a super PAC, the super PAC will identify the exempt organization as a contributor and not the various donors that may have contributed to the organization itself. So the C4 or the C6 entity will be disclosed on the super PAC's campaign finance reports that are filed with the FEC as the contributor. Now the speech now rationale has not been accepted in all of the states. Many states have cleared the way for state independent expenditure committees. So these are committees that are going to make independent expenditures in connection with state or local elections. Certain states have taken the position that state-level independent expenditure committees are in fact subject to contribution limits that are applicable to all other political committees in that particular state. And you'll see on this map the states that are highlighted in red are some of those who have said that a state-level independent expenditure committee may not raise unlimited sums in support of express advocacy communications. You'll see that that's New York is a big example, Vermont, New Jersey, Ohio, and Florida.
As we said, at the federal level, Janice had that graphic that showed sort of where the donors to the nonprofit that then give to a super PAC are not disclosed. The states are taking a different view of this, and so they are imposing a number of different disclosure requirements on organizations that make independent expenditures or that contribute to independent expenditure organizations. Some states like California and Montana have engaged in an extensive litigation over getting donors from entities that are sort of downstream. Utah recently passed a law that requires disclosure of donors, and they take a very broad view of what a donor is. It's anyone who makes a payment to an organization without receiving full and adequate consideration for the money. Now, it seems to me that that's a complicated definition. What about a membership organization where you're paying for your membership? How does that get figured in? So it's going to be a very complicated situation to determine when these rules kick in. There are organizations that have set up broad networks across states to try and minimize their disclosures. What will states do with that? What's the authority of the state to subpoena records from an organization that's 3 states back? It's going to be interesting, I think, to kind of see how that plays out right now. The other thing, as we mentioned briefly, we've talked about the primary purpose. We've talked about now that all of the inquiries that the IRS is making into 501c4s. The Senate Permanent Select Committee on Investigations has said that it's going to put pressure on the IRS. Outside groups have called for the PSI to subpoena some of these 501c4s themselves. I'm skeptical that that will actually happen, but it's entirely possible that these groups may receive subpoenas or chairman's letters to disclose some of their donors. So I think given the lack of clear guidance, this is an area that you want to think very carefully about and make sure you have a very good plan in place if you're going to be involved. Finally, in terms of satisfying the primary purpose, as we talked about, there are a variety of issues to consider. I would say one thing, if you're going to be involved in this space, don't necessarily rush out and create new entities. I've had clients that said, okay, we're a 501c6, we want to get involved in independent expenditures, let's create a 501c4 that's related. Well, now you've got a primary purpose problem, because what's the C4 going to do besides the independent expenditures? So it may be better not to run out and create a new organization, to use your existing 501c6, for example, or an existing 501c4. On the other hand, you may decide that as you're looking through this, because of various disclosure issues, a special purpose entity may be the better way to go. It just requires careful planning to determine exactly what the right approach is.
Quick point about fundraising. If you're sending out fundraising appeals and you're saying in your letter or your email, the money's going to help us defeat so-and-so, or you're even more subtle than that, there's some indication that it's going to help elect or defeat a candidate, the FEC says that you've got to have certain disclaimer language in your fundraiser. And that applies regardless of whether the ad or that you actually use the money for express advocacy or for anything other than an issue ad. It could even apply to a 501c3, because through the lens of the FEC, they don't care whether your status with the IRS is C3, C4, or C6. if you suggest to prospective donors that their money could help in connection with an election, you may be subject to the FEC rule regarding disclaimer requirements for that fundraiser. And finally, it's been much in the news. There's an awful lot of pressure being exerted on trade associations and corporations to do more by way of donor disclosure, more transparency about how political activity is being overseen. The Securities and Exchange Commission is considering putting out for comment a proposed rule that would require public companies to be more transparent about their corporate political spending and how decisions and oversight are handled regarding political activity. Oops, I'm sorry.
The next section we're going to talk a little bit about is the special rules that apply to 501c3 organizations that may want to be involved in elections in some way. The basic rule here is that the federal tax code prohibits 501c3 organizations from engaging in political campaign intervention. This means activities in support of or in opposition to a candidate for elective office. Doesn't matter if it's federal, state, local, any candidate for elective office, activities in support of or against their candidacy is considered prohibited political campaign intervention. This means that a 501c3 cannot sponsor a PAC. They cannot make independent expenditures. They also can't endorse candidates. They shouldn't be using their staff time or resources or facilities in connection with political campaign activities. There are stiff consequences for 501c3 organizations that violate this ban. They could have their tax-exempt status revoked or denied if they haven't received it yet. Excise taxes could be imposed. Penalty taxes could be imposed on the organization, and in some cases, organization managers who have participated in making the decisions. There are still ways that a 501c3 organization can be involved in election-related activity without running afoul of the ban on political campaign intervention. Unfortunately, the line between permitted and permissible activities can be murky, and it can be easily transgressed if the organization isn't careful about how they structure their activities. There are several slides here that I'm not going to go through in great detail because we have some additional material that we want to cover. But the bottom line is that 501c3 organizations can be involved in activities like voter registration or get out the vote drives. They can be involved in sponsoring candidate appearances or perhaps a candidate debate or forum. They can engage in activities like legislative scorecards or voter guides or candidate questionnaires. The key to any of these activities is they absolutely must be nonpartisan and they must be non-biased. So if you're going to engage in, for example, hosting a candidate appearance, you want to indicate that you're not supporting or opposing the particular candidates that are there, whether through biased presentation of topics or questions. You do not want to allow political fundraising under any circumstances in connection with your appearance at the event. The questions posed to candidates in appearance should cover the breadth of issues that individuals in the general electorate would find interesting based on the particular election. You should not have the questions be limited to those issues that those issues your organization happens to be interested in or that are important to your particular constituency. And you need to be broad about inviting all the candidates that may be running for that particular office.
How do you define all?
Well,
because there are a lot of minor or stand-in or placeholder candidates that may have registered but are either uncontactable either by accident or not.
The question is, how do you define all candidates? And the fact is that you can have, if you have some objective criteria for defining who may be included and who may be excluded, you will generally be on the right side of the line. So perhaps it has to do with who may qualify to be on the ballot, or perhaps
polling, if you set a 1% threshold on a poll, which is easier at the national level than the local level where there might not be a lot of polls. But usually if you can, there's ways to sort of draw the criteria. Has a newspaper mentioned them when they list the candidates who are running? Is one way that I've done it before to try and get rid of some of those fringe candidates who you're not going to be able to contact. Those are maybe if they've raised a certain amount of money under the campaign finance system, you might be able to do that. But again, the key is to have sort of an objective, bright line rule that you've put in place before, and haven't tailored that rule to exclude a particularly candidate that's doing very well, even though you might not want them at your event.
Just a quickie. Let's say you had a member of Congress who was sponsoring your bill over several years, and you decided to give them your Legislator of the Year award, and you're within 120 days of your primary, and you decide that you want to make a big deal about your presentation of the award, and so you go into the district and you invite all your members from the district, and you present the award to the candidate, and of course you might invite some trade press, some local press. Okay, I mentioned this bill that you've liked with the candidate has done all the time, but really it's about giving them this award. Where am I?
Well, I think that anytime you get close to an election like that, you do want to exercise some discretion. But your question, which is, what if my organization has a long-standing relationship with a particular legislator? The legislator has been supportive of the issues that are important to my organization for a long time, and that person is a sitting office holder, which leads me to this slide right here, which is that an organization can invite a candidate for office, so for example an incumbent office holder, to appear in an official event in their official capacity. In that situation, the candidacy and the election should not be raised or discussed by the host organization or by the candidate himself or herself under any circumstances, and the venue should really be made neutral. No political fundraising should be involved.
Okay, and I'll have to ask everyone's kind of forbearance in terms of questions for the remainder of the program, because we do have a lot more material to get through in the next 20 minutes fairly quickly, and everyone will stick around afterward for questions.
Legislative scorecards is similar to what we just talked about. If your organization is engaged in producing a legislative scorecard on a regular basis at times other than election periods, you can continue to produce that legislative scorecard even in connection with an election, provided that you do it in the same way that you usually do it in other times of the year. And again, you want this to be nonpartisan, list all the votes by the legislative body, but you can reference issues that are important to your organization. With voter guides and questionnaires, we're back to the same basic rule of thumb. They should be nonpartisan and unbiased.
Another area, and this does touch on the question before also in terms of your public communications, making sure that issue advocacy does not cross the line into candidate advocacy. And again, here we're not talking about the bright line rules that the FEC uses of express advocacy, but the IRS has a whole host of factors they look at for whether you're intervening in a campaign. And so it's important to think about, if you're going to do a public communication based on issue advocacy, if you're going to include a reference to a sitting legislator or a candidate, how do you do it in a way to make sure you're not intervening in the election? It's very important to be very careful, and maybe you decide you don't want to include the candidate in the ad. You're just going to focus on the issue without putting any names behind it. The other area where C3s can get tripped up in this area is what the staff or the leadership of the organization are doing. So it's important to remember that if an individual associated with the organization, the CEO or someone else, is going to be involved in campaign activities, that person not use the organization's resources. So be careful of using membership lists or support staff time for any political activities. Make sure that if a person's involved in supporting a candidate, that they're not holding themselves out as the CEO of this 501c3 organization, that they're there in their personal capacity. If you identify them, if the candidate identifies them as the CEO of the organization, they include a little note that says for identification purposes only, that they really downplay that role. And that anytime a person is speaking, they make sure it's clear it's their personal views, that I'm endorsing this candidate, my organization is not the one who's endorsing the candidate. And similarly, you want to be careful when you're working with 527s. Maybe the CEO of a C3 is on board of a 527 or a super PAC. Be very careful again to make sure you're not using the resources, that you're doing it in your personal capacity. And if you're doing your own fundraising, if you're holding an event for a candidate at your house, make sure again that you're doing it personally not with C3 resources.
We're going to switch gears here and talk a little bit about lobbying, which we've touched on throughout. And lobbying, as you know, lobbying activity, both direct and grassroots, is regulated at the federal level, at the state level, and in some places even at the local level. Wide variety of laws. Most lobbying laws require registration and filing of periodic reports if you're over a certain threshold. Even an organization that does nothing more than retain outside lobbyists in some states is going to be required to file reports as a lobbyist principal or lobbyist employer, even though under the federal rules you're not sucked into that regime unless you actually employ someone who's lobbying. Under many state laws and the federal law, there are tougher gift restrictions if you hire lobbyists. You may have to go through ethics training at the state level, certify your compliance with gift rules, and so on. In general, who is a federal lobbyist? It's an individual who makes more than one direct contact. Federal law does not regulate grassroots lobbying, so it actually means there has to have been a phone call, a meeting, an email, something more than one time with a covered official. We'll talk about who those are in a second. And the rule of thumb at the federal level is that you're spending at least 20% of your total compensated time on lobbying activity. Lobbying activity is not just the time you spend actually meeting or emailing, but all the preparation, research, writing, strategy sessions, and everything else that you have in connection with your direct contacts. So again, any sort of direct contact will do, oral or writing, or I'm not sure what email qualifies as, but.
And Larry, let me just interrupt you for a second, just to clarify for everyone, because this is where it can get really confusing. What Larry's talking about is the Federal Lobbying Disclosure Act, the law that was originally enacted by Congress in, I think, 1995, that requires registration and reporting by organizations and lobbyists that do certain types of lobbying. We're going to talk about what those are. These are not limitations of any kind on lobbying. It only requires registration and reporting and disclosure of those lobbying activities. The definitions and things that Larry's talking about come from the Lobbying Disclosure Act. But if, as many of you are, you come from organizations that are exempt under, say, Section 501c6 or C4, C3 of the tax code, there are alternative, different definitions of lobbying, different exclusions from the definition of lobbying that are found in the tax code. While those are relevant for tax code compliance, and we'll talk about that too in a minute, there is an intersection between the two where some of the federal tax code definitions can come into play for Lobbying Disclosure Act reporting purposes. So just keep all of these different kind of buckets in mind. It can get very confusing.
Right. No, very good point. We're really focused now is what's going to trip your what's going to trigger a requirement that you register and report under the Lobbying Disclosure Act, not to the IRS, but file reports to the House and the Senate regarding your lobbying activity and your expenses. Again, just more than one contact. What can that contact be about? Almost anything. If you're trying to influence policy, it relates to the award of a contract. You're trying to influence legislation. It's very broad. Important to remember that there's no lobbying-free zone. So if you go to a political fundraiser, that's not a lobbying event, but you have a side conversation with someone about a piece of legislation or some other issue, that's lobbying. It doesn't matter that you happen to be in the room. The same thing goes for conferences and things like that. Again, under the Lobbying Disclosure Act, who is a covered official? The easy part is on the legislative side because it's basically everybody over on the Hill, all members and staff, everybody but the volunteer interns. It's a little more complicated on the executive branch side. Generally, it's going to apply to political appointees and very senior officials in government agencies. So when you're trying to figure out this, have I spent 20% of my time, or is someone who works for the organization spent at least 20% of their time on lobbying activity, you look at this whole range of things, planning, research, coordinating federal, state activity. The key really is a purpose test. Why were they doing it? If you're monitoring legislation that is not in connection with any bill that you're interested in or going to be lobbying on, that's not lobbying activity. On the other hand, if you've got someone spending a lot of time monitoring a bill and you are lobbying, then it is considered part of that 20% that you've got to consider and that you've got to report on your quarterly lobbying reports.
And even if you're engaging in all that background research for the intention of using it in a future lobbying communication, it gets a little tricky. You might have arguments why shouldn't be considered lobbying, but if the clear purpose, or at least one of the clear purposes of engaging in that activity is to use it in support of a future lobbying effort, then it probably needs to be counted toward that percentage test.
So as Jeff said, the impact of triggering application of the Federal Lobbying Disclosure Act is that A, you need to register, and B, you need to file these periodic reports. The reports are not terribly detailed. You need to provide some cursory description of what entity you're meeting with. Is it the House? Is it the Senate? What agency is it? Some brief description of the issue that informs the public. If they're looking at your report, what it is you're doing. And the trickiest part is that you need to provide a total, not itemized, but total lobbying expenses that you have incurred during the quarter. And that is generally going to mean the payments you make to your outside lobbyists and the pro rata salary that you pay to your employees who are registered lobbyists and those who don't meet the 20% threshold but do something that connects to your lobbying mission. So the head of your organization meets with a member of Congress for breakfast. She doesn't spend nearly 20% of her time on lobbying activity, but the cost of travel, of the breakfast, of the time has to be calculated as part of the total lobbying expenses that you report on the quarterly report. Big point I would say to remember about the quarterly reports that's often forgotten is the PR perspective. It's a public document. It's scrutinized by regulators, by the press, by your competition. So you want to not only think about what the legal obligations are, but describe the issues in a way that is helpful to your organization, not more detailed than it needs to be. We talked again, this is sort of the most complicated part. We generally encourage our clients to use timesheets to try to keep track of their time so that you have a record in the event that your lobbying reports are audited, which they can be randomly, and you don't have that excruciating moment when you're sitting down with the auditor and you don't have a basis for the number that you supplied to the House and the Senate in your quarterly report. I'm not going to get into the details here, but these are some of the kinds of expenses that need to be accounted for when calculating your lobbying expenses each quarter. Real quickly on state lobbying, I think unlike the Lobbying Disclosure Act, which has only changed substantially once since 1995, and that was in 2007, parenthetically Barack Obama's signature accomplishment as U.S. Senator, state laws change almost all the time, very scandal-driven. Important thing I think to take away about state law is that the regulation of lobbying at the state and local level has moved far away from that traditional quaint idea of going down to the State House to try to get a bill passed or defeated. And so under the state law, unlike federal law, you have regulation of all kinds of things that are outside of the traditional notion of lobbying, like goodwill lobbying, which used to be called lunch. You know, meeting with somebody to cultivate a relationship that you might want to use later to help you get a bill passed. So very expansive laws and something that you really need to take up on a state-by-state basis.
I'm going to cover some basic rules that apply to, or that Jeff mentioned before, which is that the tax code has a separate regulatory regime when it comes to your lobbying activities, especially for exempt organizations. Section 162E of the code provides that expenses incurred in connection with lobbying and political activities are not deductible by a taxpayer. Congress also decided that they wanted to enforce this rule further by requiring dues paid to trade associations that are then used for lobbying and political activities to also be non-deductible. They were always non-deductible, but an organization, a trade association, for example, a 501c6 or a 501c4 social welfare entity, has an obligation to either provide a notice to its members or to persons who pay the organization dues or similar amounts of the amount of lobbying and political expenditures that it anticipates being allocable to the members' dues each year. If they don't provide this notice of non-deductibility to members, the organization is required to pay what's called a proxy tax to cover the amount of non-deductible expenses that their members are likely now deducting because they don't realize what percentage is non-deductible. The proxy tax is paid at the top corporate rate, which is 35%, and it's paid based on the amount of the organization's lobbying and political activity expenditures in the year. So the organization has a 501c4 or 501c6 have the option at the beginning of the year to either provide a notice to members of non-deductibility or pay the proxy tax. If the organization pays the proxy tax, then any amounts that the organization incurs for lobbying and political activities are not considered non-deductible to the members. The members could take a deduction for those amounts.
And just to clarify, we're talking about a business expense deduction. Even though we're talking about nonprofits, these are non-501c3s. C3s are not covered by this law, so we're talking about a business expense deduction. And basically this rule was put in as an anti-avoidance mechanism because the primary thrust of 162E is to say that for-profit corporations are not entitled to a business tax deduction for their lobbying expenses. This prevents corporations from using their industry trade associations to be able to take a tax deduction for their lobbying. The other important point is that the calculation, the non-deductible percentage, is not based on whether you're actually using that money, the dues money, for lobbying. It's just based on total lobbying expenses divided by total dues and other similar amounts, regardless of how you actually fund the lobbying.
That's right. The tax code assumes that your lobbying and political expenses are paid for out of dues, so you can't get away from that. Larry talked a little bit earlier about the kinds of activities that are considered lobbying under the Federal Lobbying Disclosure Act. Under the tax code, this is 162E, which is applicable to our particularly 501c6 organizations. There's another set of definitions that apply to our 501c3 organizations. But under the tax code 162E, you'll see that state-level lobbying, grassroots lobbying, international lobbying, those are all considered lobbying under the tax code, even though they're not considered lobbying under the Federal Lobbying Disclosure Act. Organizations that are registered on the Federal Lobbying Disclosure Act have an option to use either the tax code definitions or the Lobbying Disclosure Act definitions when they're preparing their Federal Lobbying Disclosure Act reports. So in terms of counting your expenses and activities, you could use the tax code definitions instead of the Federal Lobbying Disclosure Act definitions if you wish. Keep in mind that if you use the tax code definitions, the idea here is to presumably provide some administrative convenience to organizations that are already required to track expenses under the tax code. But if you choose to use your tax code definitions under the LDA, keep in mind that the tax code includes a much broader swath of activities. And so when you're reporting on the Federal Lobbying Disclosure Act report, your amount spent on lobbying activities, if your organization engages in a lot of state-level or grassroots lobbying, that expense might be a little bit skewed in terms of what the Federal Lobbying Disclosure Act is really looking at. Talk a little bit about 501c3 limitations on lobbying. The general rule is that no substantial part of the organization's activities may be engaged in what's called propaganda, but it's essentially lobbying. There are two ways of measuring an organization's lobbying activities under 501c3. The default test is the facts and circumstances test. This is a vague test. This is an I know it when I see it test. The IRS has a lot of discretion and hasn't provided a lot of guidance about what it means for an organization to engage in too much lobbying under the substantial part test. The other test is a pure expenditure-based test, and it's called the 501H election. Under the 501H expenditure test, an organization has clear definitions of what is and is not lobbying, and there are a series of exceptions from the definitions of lobbying. Grassroots lobbying will be attempts to influence legislation through the attempts to affect the opinions of the general public, and those communications will be considered grassroots lobbying if they include a call to action. Direct lobbying is your traditional concept of engaging in direct communications with covered officials about legislation. Under the 501H expenditure test, an organization can ensure that it is engaging or that it is not engaging in too much lobbying, provided that they keep their expenditures below this particular sliding scale of limits. Generally speaking, a 501c3 may spend up to 20% of the first $500,000 of its exempt purpose expenditures on lobbying, and you'll see in the chart that the sliding scale goes up depending on your exempt purpose expenditure level, up to a maximum cap of $1 million. Under no circumstance can any 501c3 organization spend more than $1 million on lobbying under the 501H election. And then there is a special subset limitation for grassroots lobbying. You've heard that mentioned throughout this presentation. A 501c3 who has elected the 501H expenditure test may engage in no more than 25% of its total lobbying expenditures may be grassroots lobbying. Just like with 501c3 organizations, with the 501c6 organizations, a 501c3 may choose, if it is a registered lobbyist under the federal LDA, to use its tax code definitions to report its LDA expenses instead of the Federal Lobbying Disclosure Act definitions.
We're going to turn to one last quick set of issues to talk about, and those are the gift rules. And we're going to go through this a little bit quickly. And rather than go through all of the rules today, the purpose is really to focus on a couple of common scenarios that associations and other nonprofits may come up against. The thing to keep in mind here is that there are 3 different sets of gift rules at the federal level. The states each have their own gift rules. They're all different. So we'll focus here at the federal. There's one set of rules for members of Congress and their staff. There's another set of rules for career government officials. And then there's a separate set that for political appointees who have signed what's called the Obama Ethics Pledge. Each of them have different exceptions in different carve-outs. So I thought we'd talk about, in one scenario, a conference held in D.C., an event maybe like this one here, where you have folks in attendance, and what are the rules about who can and can't attend, and more important, not so much attendance, but who can take the food and eat the lunch, because that's the gift. Sitting in the room is not so much the gift. So at the federal level, for members of Congress or their staff, they have to either be speaking at the event or determine that the attendance is related to their official duties. So that means that someone on a staff member on the Armed Services Committee shouldn't be attending an event on wildlife matters. The rule for the size of the audience is that there have to be more than 25 people who aren't from Capitol Hill in the room. That makes it a widely attended event. And then the other key piece is that the audience have to be from a range of industry or profession. So it can't be just a company holding an event, but organizations like yours are the perfect kinds that can host widely attended events because they have folks from throughout a range of industry or that represent a variety of viewpoints. For political appointees, there's a narrower category. They have to be a speaker at the event. There's no particular number of people that have to be there. They have to have a diversity of views present. Now, they can come and attend an event, but they can't eat the food or take any of the other gifts. The key is that if they're going to speak, then they can eat the lunch. For career employees, they don't have to be speaking at the event. The agency can determine that it would further the agency's programs or operations to have them attend. Now, what's interesting is there's a different set of rules if the event is not in Washington. The travel rules, oddly enough, even though the expenses are probably greater because you're helping to fund the travel, are more liberal in who can attend. And in fact, on the executive branch, the rules are the same for both career and political appointees. And an event where it may not be widely attended, for example, in Washington, if it's outside of D.C. and you're paying the travel, they may be able to attend and they don't actually have to speak at the event. On the congressional side, It's actually a little more complicated, particularly if your organization is registered as a lobbyist. Jeff mentioned before there are times when if you register, there's certain other things that flow. In here, if your organization is a registrant under the Lobbying Disclosure Act, then the travel rules are stricter, and you can only fly members of Congress or their staff for a one-day event, or if it's on the West Coast, a two-day event. So there are very strict rules as well about how the lobbyists can be involved in the planning or make the invitations.
Is that a typo? Is that in DC?
Yes, out of DC. I'm sorry. Yes. I'm sorry. No, you know what? I'm sorry. I advanced the wrong slide. There's the conference or similar event in DC was the first one we talked about, and then a conference or similar event out of DC here. Yeah. Another common thing to do are to host receptions. Here, the key is not on the number of attendees, but the kind of food that's served. Food or drink of nominal value other than as part of a meal. So in the morning, donuts, coffee, juice. In the afternoon or evening, hors d'oeuvres, things that you stand up and eat, not that you sit down. Now, the executive branch here also, particularly with political appointees, the agencies have been very strict with this, and I've found that a number of times folks have been asked to pay, their agencies have said, you know what, you need to pay $10, $15, whatever for the food. They're quite strict on those numbers. Finally, particularly for the 501c3s in the room, educational briefings is a great way to hold an event on the Hill to talk about something other than legislation. And the key is it doesn't have to be a widely attended event. You can have just 5 people from your organization in the room talking to a room full of members of Congress or their staff and provide them with a boxed lunch. It doesn't meet the widely attended event rule, but it can be an educational briefing. 501c6s and C4s aren't able to take advantage of that, unfortunately. And then also finally, keep in mind there are ways to invite folks to your charitable events, help to raise money, get members of Congress and others to attend as well.
I just want to make 3 final points on risk management. We have a couple of our last slides about that. One is very, very important to have a set of very clear policies, do's and don'ts, who you need to go to if you need pre-approval on a gift, who is the point of contact if you're concerned about some particular activity, something that's part of your code of conduct or published in some other fashion that people can use as a resource. And related to that, periodic training. We recommend once a year, but because the laws are changing so rapidly, some help sensitizing folks, not making them encyclopedias of gift law and lobbying law, but allowing them to recognize issues when they see them. There can be no better shield, and I say this as somebody who's been on the side of the table where the regulator sits, than saying we take compliance very seriously, we have clear policies in place, we provide annual training, we can't be responsible for the fact that we had somebody go rogue. Second, I would say, and we've talked a lot about rules and complications, there's almost always a way to do what you want to do. There's almost always a way to have that event that Ron talked about, or to invite the official to come in and talk to your group at a conference. But normally the best way to do it is to ask first. You may have to tweak the event slightly, you might have to change the menu, but you can almost always achieve your goal. And then finally, and particularly because we're talking so much today about rules and regulations and requirements, is to not lose sight of what your mother taught you, the Washington Post test, whatever you want to call it. It might be that you can check all the boxes that to host your event or to engage in a certain kind of lobbying campaign. But because everything we're talking about here is so highly scrutinized and most of it's memorialized in public records, it still may not be a good idea even if the law says you can do it. And so you want to think about, always look at things through the lens of the media and your competitors and regulators. With that, let me turn it back to Jeff.
Thanks, Larry, and thanks to you and Ron and Janice for a terrific job. Obviously, we packed a lot of information into a short time. Ron, if you wouldn't mind advancing it to that final slide. Obviously, we weren't able to do more than scratch the surface, but the good news for you is that in addition to the handout materials, you'll see some links up here with a whole host of additional information you can find on our website about these topics. Under that first link, venable.com/nonprofit/publications, if you go to the topic area, lobbying and political activity, you'll see a wealth of articles on these topics. And also look at the links below, including the link to Venable's political law blog, politicallawbriefing.com. Feel free to subscribe to that. Unfortunately, we don't have time to take any more questions here in the live program, but for those of you in the room, our speakers will stick around afterward. For those of you on the phone, if we didn't get your questions answered, feel free to email or call us. Thanks again to our speakers and to everyone for coming. See you next month.